Hi guys, my name is Jing Hui and I'm going to introduce my group member to you guys. First, Natalie, Vicky, Joel, and Samuel. So today we are going to discuss on the topic about the doctrine of precedent. To give you a brief idea about doctrine of precedent, the doctrine of judicial precedent is based upon the principle of stare decisis, which means the standing by of previous decision. This means that when a particular point of law is decided in the case, all future cases containing the same facts and circumstances will be bound by that decision as signified in Coral Reef Limited and Silver Bond Enterprise Limited.
Hi guys, welcome back to the Law TV. I am your favorite host, Vicky. So, ever wonder why am I dressing like this today? So, in this episode of Law TV, we have invited a very special person who will be explaining about the court system in the United Kingdom to us. So, follow me, come on. Look, it's the Supreme Court. Okay. Supreme Court.
Hello.
Well, hi, nice to meet you.
Hi, please have a seat.
Alright,
So how are you?
doing good, you?
I'm fine myself.
So in this episode of Law TV, we are very honored to have Mr. Joel right here to explain more about the court system with us. So Mr. Joel, would you like to say hi to the audience first?
Hi, I'm one of the Supreme Court judge and I'm really grateful for this opportunity to be able to explain to you, the audiences, on the court hierarchy system in the UK.
So would you like to start explaining the divisions first?
Alright, sure. So in the court hierarchy system, there are two divisions, namely the civil and the criminal division. So we shall start with the criminal division. Criminal law is a type of public law. It is the law that identifies crimes and punishments as described in the criminal law statute of domestic law. In a typical criminal law case, the burden of proof is on the prosecution and the standard that must be met is beyond reasonable doubt.
Right, but I'm wondering, what are some courts that hear the criminal cases in England?
Right, so first of all, we have the Magistrates Court, which deals with summary offences or minor offences. Example of these offences are minor traffic offences, assaults, minor thefts, and obstructing the police in their performance of duty. Cases here are heard by either a panel or of 3 magistrates or a district judge, without a jury. The decisions made here may be appealed to the Crown Court.
But how about the much more serious offences such as murdering or raping?
So these serious offences like murder and rape offences are classified as indictable offences, together with offences like kidnapping and manslaughter. So these cases are dealt in the Crown Court and the decisions may be appealed to the criminal division of the Court of Appeal. Cases here are heard by a judge and a jury.
So I see, did we cover most of the criminal cases that actually appear?
No, actually, there is also this last point where there is what we call as triable either way offences. These offences include robbery, drug cases, assault causing bodily harm, generally more serious theft cases and others. These cases can be tried in either the Crown Court or the Magistrates Court.
Well, so from this, we understand that the Crown Court and the Magistrates Court are the first instance courts for criminal cases. Moving on, would you be able to explain the appeal process and structure for all these criminal cases?
Sure. Appeals for criminal cases are governed by the Criminal Justice Act 1972, the CJA 1988, CJA 1991, 2003, Criminal Procedure and Investigations Act 1996, and Criminal Appeals Act 1995.
Wow, that's a lot of acts.
Well, leave to appeal must be obtained by the defendant in the case, meaning a certificate from the Court of Appeal that the case is fit for appeal. A few factors are taken into consideration before granting the appeal. For starters, new evidence submitted must be capable of belief or that the conviction held previously is unsafe. The prosecution, on the other side, can also appeal against the acquittal, but only if the jury or witness is considered noble, for example, being bribed by the defendant, or the case is to have referred to the CO for the Court of Appeal for a specific point of law. The Attorney General is also capable to apply for leave to refer an unduly lenient sentence to the Court of Appeal for resentencing under the Section 36 of the Criminal Justice Act 1988, like in the Leong Vicky case. Okay, so now let's move on to the civil division of the court hierarchy system in the UK. So civil division is much more less complex when compared to the criminal division. So do you happen to know anything?
Yeah, I've actually heard of a few courts from the civil division as well, such as the county court, the Court of Appeal, the High Court, the Supreme Court, which is like more or less the same compared to the criminal division. But if I'm not mistaken, the civil division actually deals with like civil cases such as tort and property disputes, if I'm not mistaken. Am I right?
Yep.
Alright, so but I have one question over here that has been bothering me for quite a long time. I know that there's actually 3 different divisions under the High Court. So there's like the Family Division, the Queen's Bench Division, as well as the
Chancery Division.
Yeah, so but I don't actually know why, and I'm very confused the exact meaning, the definition of the Chancery Division and the Queen's Bench Division. Yes.
So as Vicky has stated, the Family Division of the High Court is a bit general. Okay, it deals with matrimonial cases like custody of children, parentage, adoption, etc. It is a bit more complex in the Queen's Bench Division and the Chancery Division. So the Queen's Bench Division hears judicial reviews, statutory appeals, shipping and maritime disputes, national and international business, etc. While the Chancery Division, on the other hand, deals with cases concerning equity, contracts, contentious probate, tax, partnerships, bankruptcy, things like that.
Well, so I've actually got another question right here, if you
Sure.
don't mind. So, why are there actually 2 courts dealing with first instance cases?
Well, first instance courts that hear these cases are the county courts and the high courts.
Yes.
So basically, the county courts deal with cases below £5,000, while high court deals with first instance cases above £5,000. So the case heard by the High Court as first instance cases are generally cases concerning a point of law, are of public interest, or is concerning the interpretation of a statute or an act.
Well, I see. So is that basically everything about the division, the court system already, the hierarchy of courts?
Well, there's the appeal process.
Well, so regarding the appeal process, I know that if I'm not mistaken, it's more like the same compared to the criminal division, right?
Okay.
So it's like the county court may appeal the decisions to the High Court, and the High Court may appeal the decisions to the Court of Appeal, as well as lastly the Supreme Court, which is where we are right now.
So if you don't know, the Supreme Court is the highest court in the UK. It listens appeals from the Court of Appeal, the civil division of the Court of Appeal, and the decisions made here are final, meaning that all other courts lower than the Supreme Court in the court hierarchy system must be bound by the decision made here.
Well, so is that all about the hierarchy of courts that you like to talk about? Would you
Well,
like to add
that's
anything?
more or less that's all for now.
Okay, so I guess that's the end for this episode. So basically, we are very happy. I bet that our audience is actually over the moon right here because we have this one of our judges from the Supreme Court right here to explain regarding everything in detail about the hierarchy of courts to us. So thank you so much, John.
Alright, thank you.
Alright, okay, thank you so much.
Bye bye.
So here comes an end of our this episode of Law TV.
So I hope you've learned something important and beneficial.
So just a small reminder, guys, please do like, comment and subscribe to Law TV, LAW TV. Alright, thank you.
The role of the Master in the High Court of Justice of England and Wales is concerned primarily with trial and case management of High Court civil claims in London, excluding committals to prison, judicial review and criminal cases. There are Masters in the Queen's Bench and Chancery Divisions and the Courts Office, and their roles differ slightly. In Coral Reef Limited and Silver Bond Enterprise Limited and NADA 2016, Master Matthew brought up a topic on how far is Master bound by relevant decision by High Court judges.
The issue of this case is about the application by defendants for security for their cause of a claim brought against them. This claim concerned the beneficial ownership of issued share in the first defendant. The application for security of cause was made on the basis that there was reason to believe the claimant would be unable to pay the defendant's cost if ordered so. Within Civil Procedure Rule 25, Section 13, Subsection 2C, the claimant had not supplied any information to the defendants, claiming reliance on the decision of Judge Andrew Smith in Sub Oil International and Adex Energy 2015 to the effect that a respondent to a security application has no duty to volunteer evidence about its financial position, nor to explain why it is unwilling to do so.
1 day before the hearing, the Court of Appeal reversed the case of Sub Oil 2015. If a company is given every opportunity to show that it can pay a defendant's cost and deliberately refuses to do so, there is every reason to believe that if and when it's required to pay a defendant's cost, it will be unable to do so. So, let's see how is the Master going to talk and decide on this case.
My lord, we had only found out about the Court of Appeal's decision this morning.
Claimant, this is not a valid argument. Lord Justice Lewison gave permission to appeal on the footing that it was an important point of practice which should either upheld or reject at appellate level. You are obviously taking a risk in refusing to provide any information.
Even if the Master is convinced that the judge is wrong, a Master is still automatically bound by the decision of the High Court judge.
My lord, however, it is not the seniority or status of the judge that is relevant, but the superiority of the court. On that basis, the decision of High Court judges and Masters exercising the jurisdiction of High Court are decision of a court of coordinate jurisdictions.
In the case of Randall and Randall, where Deputy Master Colaco Mores had to consider two conflicting cases in the Chancery Division, in his view, a decision of a Master and a Judge of the High Court are of the same standing in terms of the doctrine of precedence. They are both judges of the High Court exercising the same jurisdiction, though the jurisdiction of Masters is subject to certain restrictions. He noted that a Master has greater experience of certain types of dispute.
Well, the Deputy Master Colaco Mores was wrong in this sense because it was not open to a Master to develop the doctrine of precedent, and also according to the Section 19 Sub 3B of the Senior Courts Act 1981, Masters were not judges, they were just plainly officers. So there's no certainty in the Master's decision. If there would, then the anomalies would arise.
I I do not agree with your statement. There is no longer an automatic right to ask the judge to rehear any application made to the master. An appeal must be brought and permission obtained. It was therefore necessary to reconsider the matter on principle and under the civil procedure systems as it is at the present day. He was assisted by the Court of Appeal observations in Howard D. Walden Estates Limited and Agio, which did not put the rule of stare decisis in terms of the status of judges, but on the basis is statute of the court, and treated the decision of a deputy high court judge as of the same status as a high court judge for precedent purposes. In practice, a high court judge will not in today's world ignore reasons for a decision of a master that was in point. If a judge does not have the master's reasons for his judgment, all it means is that those reasons cannot be taken into account. However, in modern times, with the growth of computer databases easily searchable over the internet, important master's decisions are now readily available.
Master Matthews therefore rejected the decision of the High Court judge in sub oil for the reasons given by Court of Appeal in the same case in reversing it. The upshot of this was that it was open to the master to draw the same inference from the claimant's failure to disclose information about its financial position in the same way that the Court of Appeal did in sub oil, by reversing the decision of the High Court judge. The master granted the defendant's applications and ordered security for costs, the claimant's failure to provide information playing no small part in the decision.
Okay, so there are many advantages to the doctrine of judicial precedent, with one of the main advantages being the ability to save time when making a decision on the case. If a court is already provided with an answer to a problem in which they face, it will not take as much time to reach a reasoned conclusion. This is because the court will not be required to analyze the case and make a decision, as they will already have the answer before them. This is a significant benefit within the judicial process. An example how effective judicial precedent can be is exemplified in the case of Hunter and others and Canary Wharf Limited and London Dockland Development Corporation. Here, the court did not have to form an original precedent, most could merely apply a previously established principle to the issue at hand. Another advantage, which has already been mentioned, is the consistency between cases. This strengthens the system and is also likely to reduce crime, since those who are aware of the consequences will be less likely to commit a criminal offense. For more traditional legal issues, consistency may be desirable to promote certainty and facilitate the formation of parties' legal expectation. Besides, greater fairness is also provided as cases with similar facts will be treated the same. This is of course unless there is some further fact which is material to the decision, as the court will then be capable of reaching a different conclusion. The existence of a judicial precedent may also prevent a court from making a mistake, as guidance will be provided as to how a case ought to be dealt with. Therefore, a judge will be less likely to make a mistake when reaching a conclusion, and the decision will be deemed to be a lot stronger. It will make it difficult for a court decision to be contested, as there will be case law in place that will back up the court decision, as shown in Cardim and Brand London Borough Council. This is important in preserving the integrity of the justice system and maintaining judges' confidence.
There are disadvantages of judicial precedents. Operation of judicial precedent is said to have the following disadvantage. First, judicial precedent does not encourage flexibility in judicial decision, as all courts must abide by the principle of stare decisis in their decisions. Secondly, judicial precedence is lack of judicial autonomy. This observation is corroborated by the principle of stare decisis, which states that any any lower court that failed to comply with the applicable law and decision laid down by the higher court shall have its decision corrected or reversed. Thirdly, judicial precedent is conservative as it does not allow for quick transformation and application of law in line with the changing situation in the society. Furthermore, judicial precedent focus more on compliance with precedents rather than the quality of law and decision discharge. This made the practice of judicial precedents to be fraught with restrictions. Last but not least, judicial precedent is stereotyped in practice, and this weakens the power of judicial independence and accountability among the courts.
Hey dear, I have something to tell you.
What?
I think I'll be going to somewhere else to work for a while.
Where?
I'm not too sure, but just be for a while, okay?
Is it going to be long?
I'll be paying you £30 per week, don't worry, you'll survive.
Fine. Who is she?
She's my girlfriend. She's my wife.
I want divorce.
Then I'm not paying you £30 anymore. If you want, if you like it, bring it to the court.
Fine.
Okay, so the court held that the wife could not enforce the agreement because first, there's no consideration. The wife had not given any consideration for the husband's promise. Second, there's lack of intention to create legal relation. So in this case, the case has been original precedent for the following cases. So what now?
What?
You promised to give me the property, you know.
We didn't intend to be bound, so?
Fine, let's go to the court then.
The promise was intended to be binding. The court held that Balfour and Balfour's case is not applicable here, and the parties that were living together in amity but about to separate was presumed that they were intended to have a legal contract. We hereby submit that we agree with the statement that states that the higher court should bind the lower court. This is because it is to maintain a certainty, and it is to have trust from public, to trust judiciary from making judgment. And even so, even if the judgment was made wrongly, the following cases can use the tools of precedence to distinguish, overrule, or even reverse the previous judgment. There are three main tools of precedent that we can use, which is distinguishing, as you can see in Balfour and Balfour and Married and Married, overruling, which is to overrule from overruling is usually used in appealance, and is also to reverse the previous judgment. Thank you.